that your principal objection to it, and why do you describe it as having no constitutional basis?
Thank you. Now, oral is an acronym for President John Mahama's committee tagged Operation Recover All Loot.
Indeed, yes.
And Operation Recover All Loot has been mandated, to receive and process complaints, evidence of corruption or graft or loot by persons, by high-ranking state officials, for further action. Up to now, I think that no one knows exactly what the legal status of oral is. So it remains a concept, a proposed concept, through which President John Mahama seeks to deal with the issue of corruption, by state officials in the country. I mean, I am in full support of any step that the president may take, to stem the tide of corruption in the country. But whatever is done, must secret within the confines of our constitutional governance. There is a constitution, the 1992 constitution. The constitution, has created entities, that have to deal, with issues of corruption. So we have, for instance, Xtra, we have the Yoko, we have the BNI, we have the police, and others. So if the president wants to fight, corruption, I think that it's a question of resourcing or retooling, the constitutional committees. Then let us do so. But if we add, to the list that is already in existence, something that no one, knows whether it has been legally, created, or whether it is a body that, is without legality. That, only the president can tell. But from what we have been reading in the papers, it seems to me that oral lacks legality. It has no support in the constitution. It has no support, in the various statutes dealing, with crime in the country. So to that extent, I think that the president needs to do more, much more than what we are seeing. Then when you look at the composition of the committee, which is chaired by the Northern Member of Parliament, Honorable Samuel Kujeto Ablakwa, it has a former Auditor General, Daniel Yao Domelevo. And as you recall, this same distinguished public servant has some problems with the Nana Akufo-Addo led government.
The previous
government,
yes.
The first time they acting for the level, should not be a member because he has, some issues with the former government, with the Adon government. You take Commissioner of Police, Kofi Boakye, he was targeted from the perspective, was targeted by the MPP government. Now, if you ask the person to go after, people suspected to have looted, the state, and he has a bone of contention with regard with, some of the very persons who perceive they went after. He's also going to go after them. As for my friend Martin Keku, I think he has undertaken to, even if it were left to him alone, to tackle graft and in the country. So I have nothing used to comment about him. Journalist Raymond Archer, has the for fighting, corruption and all that. So all well and good. but they can gather, the pieces of information forward to the constitutionally mandated bodies, that tasked to deal with such issues. That is where, I agree with the establishment of this amorphous, entity called oral.
Right. Lawyer Ansah-Asare, if I could interrupt you a moment. You've described in detail there the 5-man membership of the oral team. As you say, there might be question marks over at least 3 of the members who you describe in effect as being politically skewed. One, in a way, perhaps, though, shouldn't be surprised if this committee is politically skewed. Of course, it is the product of what was an opposition party which has been vociferous in its criticism, particularly of the immediate past government. It was not made entirely clear in the setting up of the committee how far back Oral's investigations would reach, whether this was a committee that was going to remain open to submissions of evidence of malfeasance by politically exposed persons or public servants dating back to just the start of the Fourth Republic or even earlier, or whether it was going to be limited to the immediate past government. By the sound of the initial investigations, the initial presentations, it would appear that the immediate past government is very much the target, and one would say, well, you wouldn't expect anything less. I wanted to ask you, though, about, if you like, the semantics of the legal basis on which it has been set up. Dr. Dominic Ayine, the Attorney General designate, during his vetting in Parliament on Monday, defended the constitutionality of the oral team, describing it as being in line with foundational principles underpinning our Constitution, and indeed, of course, in the very preamble to the 1992 Constitution, which guides our Fourth Republic, it sets out the principles or the commitment to freedom, justice, probity, and accountability. Accountability being the key term to which he points there. He described it. His term was it being oral, being a non-legal body, which he said left it completely within its rights to operate formally, perhaps along the lines of a private investigative body or a private detective. Would you agree with that, or do you think by virtue of having told Parliament's Appointments Committee that it is non-legal, to use his term, the suggestion is that it's extrajudicial, extra-constitutional, and therefore illegal?
No matter how you describe, it is not backed by law yet. Until it is backed by law, it is illegitimate. And my submission is that whatever must be done in the name of good governance must have support in the Constitution. So far, under the 1992 Constitution, there's no entity known as Operation Recover or Loot Committee. There's no such entity. And therefore, to that extent, it is unconstitutional. We don't have to wait, to go to the Supreme Court to find out whether, it's unconstitutional or not. It is not. It cannot be found in the Constitution. It is not there. That's why I refer to it as amorphous. Now, what the Honorable Attorney General Designate, Dr. Dominic Ayine, did explain, was that yes, he concedes, that there's no, law backing it yet. Yet, or nevertheless, he says that overall, it can function within, the tenets, of the constitutional framework. I don't think I can agree with him on that. It is not a perception. Whatever, is being done must have some constitutional basis or legality. If the thing is unconstitutional, it's unconstitutional. You cannot, collect pieces of legislation and say that, it could it could, fit itself happily within one or two of those pieces of legislation. It is not. Either it is, within it or it is without. We are saying that, it is not within it, so it is unconstitutional. Secondly, it seems to me that the whole concept of oral, is to task, persons suspected of looting. And so far, the information that the committee, has put out, for the consumption of the general public is that, the looters have been MPP looters. I'm telling you that, when it comes to, looting, NTC, CPP, MPP, whatever, they've all looted over the years. So it is not something, that is peculiar to the Nanado government. Amongst the NDC functionaries, you can find looters. So if it is the objective of President Mahama, today we grasp the way to go about it is not through oral. The former Auditor General Daniel Domelevo, who is himself a member of the committee, will testify or attest to the fact that we have lost, that deal with surcharge. Some of these things, the people can, be surcharged. Maybe they didn't lose. But if we want to be honest with ourselves, then we should open, the net wider, just, widen the net. And you see that ORA will catch NDC looted. ORA will catch MPP looted. ORA will catch CPP looted. So, pinpointing the MPP functionaries as the targeted, object, to me, is unjust. It's unjust.
And indeed, if you like, the information put out by the oral team suggested, as you said, a particular focus on the Akufo-Addo governments, although it has not necessarily been stipulated in any terms or any kind of rules or regulations it may have devised for itself. But it has clearly offered itself as an information gathering, an information receiving and gathering organization. Some people might say in its defense that's on a par with me as an individual. I'm Nanaya Mensah. My name does not appear anywhere in the 1992 Constitution, but if I were involved in a matter that I wanted to bring to law through the constitutionally mandated bodies, whether that's the law courts, whether that's the Ghana Police Service or any other investigative or prosecuting authority, that I have the right as an individual to go out and gather that evidence and put it together as a dossier to be presented to precisely those constitutionally mandated bodies. The Mahama government might argue that if we are to wait for reform of the constitutionally mandated bodies to ask them to investigate the immediate past government, one might wait around for rather a long time and a lot of the evidence might be destroyed. So it has set up this private venture, which is entirely privately funded, and that it's within its rights to do so.
My sister, the whole thing, turning out into a trial, which is not good, for the oral committee members as well as the people they suspect who have looted. So what is going on now is a trial, of the so-called looters with the court of public, opinion. That is not, what the Constitution has. The Constitution, has envisaged a governance system where people's reputation, will not be injured, but, will be protected. Where people will not live in fear. Where, people accused of committing crime, will go before, the constitutional bodies, legitimately, created, to handle such issues. But if you set up a committee that, is not by law, all the committee is doing is releasing information about who has looted what. And the committee's mandate excludes entity functionaries. It is inequitable. It is not fair. It is unjust. And the point we all need to say is that we did not vote. We did not vote for the current, government, for the president, only to come and create, an amorphous body, to catch suspected criminals. There's nowhere in our jurisprudence that we have, suspected criminals. If a suspect, the police must arrest them, invite them to the police station, obtain information from them. And if it is something that, is prosecutable, then the police will know, what you do as agents, or the executive arm of government. So, for now, I think that ORA must be scrapped. It's a waste of, complete waste of time, complete waste of resources. It's a witch hunting concept, that is, in future like an octopus. And nobody is supported. Once it begins to devour, innocent people, we should ensure that it is better for the general citizenry to live, in peace and stability and not in fear. Tongues have started wagging that this person did that. How many NDC, former ministers, are you aware have been invited? So far, it's all the NPP. Is it only NPP ministers who are here?
So clearly,
you know that it's not only NPP. Don't we have some peace amongst the former ministers of the NPP, or even current NDC functionaries? So let's stop this witch hunting, thing and good governance. What the Constitution has mandated the president to do. Nowhere in the Constitution has any of our presidents mandated. And I do think, something similar. And we all criticize President Obama, has enormous goodwill now that I would suggest and advise strongly, should not happen.
So, as you say, the what seems like the politically skewed nature of the inquiry by oral, the targeted nature of it being against natural principles of fairness and justice, also the high-profile approach adopted to investigations, most recently in the case of the Director General of the National Investigation Bureau, Nana Tobra Kwaku, and the question of the matter of some acquisition of land. Apparently, his initial legal action seeking to question the basis of allegations made against him by oral, by his lawyer, leading to him being served with a letter by his employers accusing him of misconduct, more about which in the coming days. I wanted to ask you, Lawyer Ansah-Asare, what the room is for manoeuvre, given we are where we are, and clearly the NDC government, if nothing else, has a popular mandate to pursue investigations into allegations of corruption by past public officials. Given the level of mistrust, particularly in the judiciary. Even during the inauguration of President Mahama, we saw the jeering of Supreme Court judges by party supporters at Black Star Square in everything from Afrobarometer surveys to popular straw polls by news-gathering organizations, judges increasingly featuring low in public perception of fairness and accountability, and particularly amongst the state security security services, the police, which are constitutionally mandated to be the prime investigative body and indeed sometimes the prosecutorial body in matters involving crimes. Where should we move from here, given the level of public mistrust that there is in the bodies stipulated within the Constitution that should be pursuing some of these matters to do with malfeasance in public office, notably the Office of the Special Prosecutor?
Well, I mean, there's a wide-ranging issue. But first of all, you agree with me that the regular courts, have been in the system for well over 150 years. The perception, of public confidence in the judiciary, is very low, at the moment, I must confess. But it is better, to retain them, than substitute them, with more false bodies like oral or, the mentioning of the return of tribunals, tribunals, community tribunals. I don't think, Ghanaians voted for, the and to bring back, bitter memory. Any Ghanaian who have had some flirtation, with the public tribunal concept will tell you, that it's not something, good to try to map out at all. And any mention, of community tribunal or the tribunal system only brings, bitter memory that have been lingering in the mind of the majority of Ghanaians. The legal part is, better. With regard to the, office of prosecutor, I think that it's another, avenue, to make corruption, to increase corruption in the state. The people, who will be selected functioning as the special prosecutors, we know the level of integrity or honesty. So we don't. And, so far, apart from the Honorable Martin Amidu, who showed some glimpses of, real work, I don't think, the other people who have, have done anything to write him about that. For instance, stop for their retention. I will not. When you try to deal with the issue of corruption, against perception of the judges, being corrupt, every Ghanaian is corrupt. We are all in it together. All of us are corrupt. It is just the speed or intensity of corruption. We don't want to say this is but the truth. The truth of the matter is that every Ghanaian is corrupt, including the clergy. We are all corrupt. So it is not only judges, or lawyers or former ministers. So let's find a way to deal with corruption. I have always held the view that any government that is voted into power in Ghana and makes corruption, the center stage of its governance is going to be the most corrupt, government, of our time. This thing is started as aura and this thing, and this, let's say, 3 months here of the allegations of bribery, attempt to bribe them, attempt to share the loot, attempt to do this or that. Let us leave this thing and of the bodies, the constitution, has stated and time, to examine, such aura. You have no place, the governor, of modern Ghana. The Office of Special Prosecutor of the DPP, the Director of Public Prosecution, can be resourced to prosecute, criminal offenses. So prosecutorial powers must not be taken from the constitutionally, created be given to amorphous bodies like oral, that now they are trying people, in the court of public opinion, enduring people's, reputation, assassinating people's reputation. So even before they forward, their findings to the president for, necessary action, they would have injured, the reputation of, very well respectable, civil servant. And when we continue to do this sort of thing, a day will come in our history that nobody will be, be educated, to work, for mother Ghana. This is where I find, the way we go about, governance in this country sometimes a little troubling. It's mind-boggling, indeed, that in this day and age, you can have a committee that will wake up, in the morning, the first thing is through some information, the suspect of the public, general public, this person has looted, that person has approached us to do it. Even before they submit their report, they would have, the innocent people would have been roundly condemned, and all that they will have to, wait for is, public lashing at them and now directing the president what to do, to innocent people. This is the extent that I agree with the existence of, the aura. Sometimes, some people describe it as a proposed ethic. If it is proposed, then it has nothing to do now because it is, a proposal, only. If it is a proposal only, what are they doing?
Well, we know that the committee has very much got up and off its feet and is active and is actively working now, viz. The reports we have heard and the responses, as you said, adopting a very high-profile approach, trying people almost in the court of public opinion.
I disagree with you that it's a high-profile approach. It is not. It is hounding. It is out to hound and persecute, people. And we should stop it. Hounding out people is not in the best interest of governance. So it's not high profile. High profile in the sense that they are damaging the reputation of innocent people. That is it, the high profile character. That is all. And that is, their stock in trade. Such committee, that is their stock in trade. Put fear in people, intimidate them, in order to obtain, some information. If it were properly analyzed, you see, and you agree with me that it will constitute duress. It will amount to duress. Coercing people, to say things that they otherwise might not have said. It's not high. It's not high profile at all. It is, the whole thing is illegitimate.
As you
it is illegitimate.
Illegitimate, you see it as illegal and indeed against all principles of fairness and justice. But where we are politically, it has a lot of public support precisely because it is what you describe as a witch hunting operation, and the current government is unlikely to roll back from it. What do you see happening in the first few days if eminent people involved in the law like yourself have objections to it on such fundamental bases, including its constitutional basis? Can you expect a legal challenge to be brought in the coming weeks against the constitutional manner of operation of the board, and therefore looking for it to be rolled back under the basis of the very law under which it claims to operate?
No, I don't foresee any legal challenge at this moment. The challenges will, come up when, they try to, prosecute them based upon, information. But then the legality of what, they do, will come into play. For now, Ghanaians will leave them, to, whatever they want to do. But, my sister, the people you claim, are, fully in support of them, are part of, those who say, arrest and crucify them, arrest them. Once, one of them, is arrested and dealt, then, they will somersault. They will start now condemning President John Mahama, for, trying to create a body that is, unlawful, that is unconstitutional. I mean, majority of Ghanaians are like that. To all begin, to sing the praises, of people who are building, found themselves in power. So as for me, I have adopted a wait and see attitude, and by June, we'll know where the case, will fall. My good advice, to President who seems to me to mean well, is that we shouldn't listen to too many people, before he decides to embark on certain things, because most Ghanaians will initially, and that was Nanado's downfall, most Ghanaians will initially pretend, that they are on your side, when in actual they are against you and give you astray. So I see in this, oral thing, an avenue, of escape. Some of the people, I mean, if we want to be honest about it, let us subject the 5-member committee, to public scrutiny. My sister, you see that they are complex. So I would say that they are clean. Nobody is angelic in this country. We all have, some skeletons to hide somewhere. So.
Right. I hope no particular fingers being pointed at particular members of the 5-member oral team, but lawyer Kwaku Ansah-Asare, thank you very much. Rather pessimistic view, but you looking into your crystal ball there, you give it 6 months, and you see at least some aspects of Operation Recover All Loot unwinding. Kwaku Ansah